Well, welcome everybody. I think we'll start now. So it was, preparing for this talk, I was a little conflicted about which topic to choose because I'm working on 3 projects at the moment, and I chose the 3rd project. The first one was I'm working on a book. I have a contract on Me Too, sort of reflecting on Me Too. And I decided that I wouldn't do it for a presidential address because my thoughts need to be refined, and I knew I would make some people cross, make some people angry with some of the statements, and others, of course, would be in agreement and so, but I just felt that I wasn't ready for a controversial issues. Then the other is a project on racial reconciliation, redress, and reconstruction that I'm working on at the moment. But then Michelle Goodwin and Greg Schaefer sort of relieved me of the choice, and they invited me to participate on a panel that they organized. And so then I was left with this 3rd topic that I've written about. I just finished writing the essay, and I thought I would talk about it. And I'm going to talk about the life of South Africa's first Black Chief Justice, Justice Ismail Mohammed. And yeah, Black in South Africa refers to indigenous Africans, Indian people, South Asians, and people who are designated as colored, as I am. So I chose to talk about Ismail for several reasons. The first is when we think about South African lawyers, everybody knows Albie Sachs, Edwin Cameron, and so on. Very few people know Ismail Mohammed. But mostly I wanted to talk about him because we as socio-legal scholars study, amongst other things, the various influences on law. And one of the profound influences on law, I believe, is often individuals or groups of individuals. And I think Ismail was such an individual. He had a profound influence on South African law. And that's one of it. So I thought it would make a good topic. He's also probably the only person I know of who has served as Chief Justice in 2 newly independent states. He served as the Chief Justice of Namibia after their independence, and he served as Chief Justice of South Africa. So he was the first Black Chief Justice in both countries. And my talk about Ismail also tracks nicely with the theme of this conference, which is crisis, healing, and reimagining. Crisis, one of the descriptions of the period of apartheid was one huge crisis. Healing, which South Africans have grappled with and continue to grapple with. And reimagining, which is a constant process since 1994, and particularly the process of reimagining the constitutional project and how the ordering of the wider society. So I want to thank you for attending this talk today. As the airline announcement goes, I know you have many choices and you chose to join me today, for which I am grateful. So how do you record the life of an extraordinary person? How do you ensure that your reflections adequately give life and meaning, as well as honor a person who was one of the most skillful orators that you have encountered, for whom words were his stock in trade, and whose command of the English language was exceptional, who was also just as comfortable quoting philosophers, Eastern and Western, as well as legal texts, with trepidation and not a small amount of pleasure. Because reflecting on the life of Ismail Mohammed, although only in a limited way, in this essay, and my talk is based on the essay that I wrote, is a reminder of the capacity of human beings to thrive despite the greatest odds, to rise above their historical destinies and thereby change not just their own trajectories, but those of their societies. So in the essay, I attempt to highlight and explore the experiences and achievement of this great South African patriot, lawyer, and judge, whose life was cut short far too soon, and whose contribution to South African law has yet to be fully appreciated. Writing about Ismail Mohammed is a challenging proposition, for he was a complicated and enigmatic individual. His assured and confident external demeanor sometimes belied an inner dissatisfaction, a restlessness, which was a feature of both the tumultuous times in which he lived, as well as the psychological or emotional toll that such times inflicted on him. In other words, his outward legal combativeness reflected the deep and painful emotional response to apartheid law and its myriad injustices, which he experienced as a human being and as a brilliant lawyer. Now, what I want to do in this essay is to carve out the biography of Ismail, and you'll forgive me if I spend a lot of time talking about his life as an advocate and him leading up to a judge, and I'm linking it to his jurisprudence and choosing particularly three cases in which I try to weave a thread from Ismail's life, growing up in South Africa, being an advocate, a barrister in South Africa, and then the judge and his jurisprudence. So I want to start with a story which was told to me. It's a humorous story, but also quite sad. Another very prominent South African advocate, whom you all know, barrister Sir Sidney Kentridge. I visited with him in 2019, and I was telling him I plan to write about Ismail Mohammed. So he related to me this incident, which I'm going to relate to you now. Sir Sidney told me that he was chair of the General Council of the Bar in South Africa during the early 1970s. And this was a time when apartheid was in full throttle, and apparently there was still a sense that the system was going to be sustained and so on. So this is the early 1970s. Now, the widespread protests that were ultimately to lead to the demise of apartheid were not yet in full swing, but they were on the horizon. So Sidney tells me that every year there was an annual dinner hosted by the General Council of the Bar at a local downtown Johannesburg hotel, and this was attended by all the advocates. Now, since the hotel was situated in a designated white area, Ismail, who was then the only Black advocate practicing at the Johannesburg Bar, this is the early 70s, he would not be permitted to attend the event without prior permission from the government. So what Sidney did was he was very keen for Ismail to attend, so he personally took himself off to some inconspicuous apartheid government office in downtown Johannesburg, where he said an officious-looking Afrikaner gentleman listened to his request for permission for Ismail to attend the annual dinner. And he explained why to this bureaucrat why it was so important for Ismail to attend, talking about Ismail's status as this respected advocate and so on. And of course, Sidney Kentridge is a brilliant advocate, and he says that his advocacy skills would come in handy, but as in the nature of these things, there was no certainty that his request would be granted. So he paused to tell me to emphasize how this Afrikaner gentleman had listened very intently to him making a request. And then he described to me a considerable silence that followed after he made his request to this bureaucrat. And then Sidney said to me, "So what do you think the first question that he asked me after listening to me and after the silence?" So now I'm thinking, I said, well, maybe he asked what was the number of the guests, or the duration of the event, or the contents of the program. And Sidney, in his very dramatic way, said, no, he said, the question that this Afrikaner bureaucrat asked me was, will there be dancing? And of course, that made me howl with laughter, because it seems such an absurd question to come from a bureaucrat after this a plea for permission. But in many ways, this was not absurd. It was so reminiscent of apartheid South Africa. In fact, the question reflected the preeminent concerns of the bureaucrats of the apartheid state at the time, that no matter how accomplished and brilliant a Black person may be, and no matter the professional setting, there was to be no physical mixing of the races, and dancing together was a taboo. Not that Ishmael danced at all, but that's another story. So this was the topsy-turvy world of apartheid. Now sort of it's fading in our individual and collective memories, but its pantomime-like qualities and the consequences, as has been pointed out, have caused irreparable psychic and other harm to South Africa. So Ishmael, when I was writing this essay and talking to various people who went to university with him, there are still 2 people who went to university with him and people who had practiced with him earlier. It was difficult because I was a law student in the 1980s when I met him, and he was one of South Africa's preeminent defense lawyers, involved in some of the most important political trials of the 1970s and 1980s. In many celebrated cases, he made legal history by pushing the boundaries of apartheid law and secured freedom for defendants when such results were unthinkable and sometimes seen as legally unrealistic. Remember that South Africa did not have a constitution or Bill of Rights. Apartheid law with supremacy of parliament and the myriad of racial laws as well as security laws made legal victories very, very difficult. Ishmael was a formidable figure and I was quite in awe of him. He had a reputation for being mercurial in temperament, a demanding friend and colleague, fiercely curious, and some would argue easily offended. But as in all things in life, context is everything. And as in the essay, I talk more about Ishmael, and as I point out that reputations often belie the entirety and complexity of an individual, namely that curiosity can be refreshing, that a temperament that displays passion, especially for justice, often expresses itself in anger and offense, and that sometimes being demanding is the mandate of friendships. It enables personal growth, often leading to personal enrichment. And Ishmael was a loyal friend and colleague. In the paper, I talk about, and for purposes of time, because I do want to get to the cases later on, what I do in the essay is look at the Truth and Reconciliation Commission and how it recorded the brutality of apartheid. And the testimonies of the victims, as is now commonplace, the testimonies of the victim, the families, and so on, were harrowing, with a full and unblemished display of trauma and emotional devastation left in the wake of apartheid's racial terrorism. So the TRC explained, and particularly the victim's testimony was extremely harrowing. It produced countless materials and so on. There was an Academy Award winning or Academy Award nominated documentary about the TRC and so on. It was a story of moving public testimony with this performance, the rituals of forgiveness and reconciliation between victims and perpetrators. But the story of the TRC is not the story, the only story of apartheid, and it's a small part of the story of apartheid. The story that I want to link to Ishmael is the story about what recent research has referred to as microaggressions, as well as the macroaggressions of apartheid. In other words, the unseen daily reminders of the institutionalized racism that was the hallmark of apartheid. And Ishmael experienced these daily degradations for several years, decades, before 1994, and he was appointed a judge. But I also point, and I'll talk a little bit about the establishment of his practice, that he thrived and excelled under these conditions is a testimony to his strong character. Ismail was born in 1931 and he died in June in 2000. He was born in July 1931 and he died in June 2000. And so he lived only 6 years of his life in a democratic South Africa. During the rest, the 62 years prior to democracy in South Africa, he lived in apartheid South Africa. And his death came at the age of 68, just 4 years after he was appointed the first Black Chief Justice of South Africa, and 5 years after he was appointed the Deputy President of the Constitutional Court. So his short life seems so cruel. And as I said, that although his influence on South African jurisprudence is noteworthy, his time as Chief Justice and Deputy President of the Constitutional Court, as well as the Chief Justice of Namibia, was too brief for him to leave the kind of legacy that we associate with judges who have served for a longer period, often several decades. But as I said, even in this short period in which he served in these judicial leadership roles, Ismail left his mark. Now, Ismail was not allowed. He grew up in Pretoria. He grew up in a small, very close-knit Indian community. Under the apartheid laws, under the Group Areas Act, various neighborhoods were set aside very, very specifically for the colored community, for the African community, the Indian community. And Ismail grew up in a small Indian community in Pretoria, which is the administrative capital of South Africa. And he was the eldest of 6 children brought up in a very devout Muslim family. And he comes from very, very humble beginnings, but he had great ambitions, and very, very early on in his life, who he was as a leader was obvious. At Wits, he became a student leader of notes, the University of the Witwatersrand, Wits. One of the people at university with him was Justice Richard Goldstone, who became the Yugoslav tribunal prosecutor and so on, and also a judge that many non-South Africans know. But Richard Goldstone told me about what an impressive student leader Ismail was. And Ismail had particular impressive skills of oratory. So Richard shared with me the very first time that he heard Ismail speak to a large student crowd at university. And Richard says, well, after that, he was my hero. But what was remarkable about this time was that Ismail was a student at a university set aside for whites only. As I said, at a time during the 1950s, apartheid was very strong. But inklings of his courage and determination were ever present, to be witnessed throughout his remarkable life. Because of the Group Areas Act and apartheid law, he was not allowed to be admitted as an advocate in Pretoria. Even though he was admitted as an advocate and practiced in the neighboring countries of Lesotho, Botswana, Swaziland, and Zimbabwe. But he was allowed to practice in Johannesburg, which is an hour drive from Pretoria. But in Johannesburg, he was not allowed to have chambers. So he could be admitted to practice, but he was not allowed to have chambers in the building where advocates had their chambers because of the Group Areas Act. And so what he did was, and he shared in his papers and his speeches, he often spoke about the time when the practice was for him to squat in the offices of supportive white colleagues when they vacated their offices for short periods of time to go to court and so on. And then he would also, if he interviewed clients, would have to do so in the library of the bar chambers. He was not allowed to eat in the lounge of the chambers and so on. So for him, setting up his practice, there were huge impediments. And one of the things that I had always had difficulty with when I first met Ishmael was, and now I understand it at this age, but Ishmael was particularly angry at white liberal colleagues. And I couldn't understand it because some of the white liberal colleagues were some of the giants of the anti-apartheid struggle. Arthur Chaskelson, you know, a whole bunch of people who practiced at the Johannesburg bar. Richard Goldstone was also there, George Bezos, all these people. And I began to understand the reason for his anger, because the many, many years that he was denied the right to have a chambers at the Johannesburg bar, other advocates, as Richard Goldstone pointed out to me, just carried on as business as usual. They shrugged, they couldn't do anything, and so they carried on their practice. There was not a lot of hashtag anything at the time. When Ishmael got chambers was when he was an adversary against an Afrikaner advocate who was representing the government, and he was representing a client, a black client. And the advocate, this apartheid supporting advocate, wanted to serve papers to Ishmael, and he discovered then that Ishmael didn't have permanent chambers. And he took himself, this advocate took himself off to the Minister of Justice, as these things are done, because they all belong to the Broederbond and so on, this group. And the Minister of Justice then provided permission for Ishmael to have chambers in Johannesburg. And that is one of the explanations I have for Ishmael's anger and his abrasiveness, because for a long time, he was not allowed to do this. And who arranged for him to get a chambers and who went out to bat for him was an Afrikaner advocate. So in the essay as well, I talk about Ishmael during the most notable apartheid trials in South Africa. And it was in the courtroom that he flourished. He had a particularly combative style, which we today may balk at, but fighting the apartheid state and the clients that he was going to represent, for them, losing meant either life imprisonment or very long terms of imprisonment or the death penalty. And it was in the courtroom that Ishmael sort of flourished. And it seemed so effortless to him, considering that the struggle was often a David and Goliath one, with the apartheid state using all of its formidable resources to crush dissent. And the courts were the places that were used to crush dissent in South Africa. And they also did so cloaked in the respectable garb of legality. All the trappings of law and legalism were brought to bear on the state goal of suppressing dissent, of ruthlessly destroying political dissent. So as I said, Ishmael was very much part of this courtroom drama in which he represented some of the most important political figures, then anti-apartheid activists who later became ministers and leaders in the new dispensation. So there were some victories that I talk about, some very prominent cases that some of you may or may not be familiar with. But what those cases generally were classic illustrations of how the courts were determined to use, the government was determined to use the court to stifle political opposition, and how Ishmael, with his extraordinary combination of skill, particularly oratory skills, and his ability to see, to ensure that in fact apartheid lived up to the sort of cloak of respectability, and he succeeded very much in that. So that was just to give you sort of the background of his practice and how he came to be a judge. Now I want to talk about Ishmael as a judge, and I'm just going to focus on 3 cases that for me illustrate the sort of Ishmael as the judge and as the advocate, his experience and what he brought to bear to his judgments. And so it's just a snapshot. There are many, many other cases that we may be able to talk about. But his jurisprudence in many ways reflected his commitment always to justice and equity. These were what he dedicated his life to. And as I said, his time as a judge was relatively brief. He died in 2000. The Constitutional Court was set up in 1994. He was appointed as a judge in 1993 before the new government was in place. But because at that point there were 200 judges in South Africa, all 200 were white, all were male except for one woman. And so Ishmael joined the judiciary in 1993, and then, of course, he was appointed as Deputy President of the Constitutional Court in 1994, and he died in 2000. So when you read Ishmael's judgments, just as you read his arguments before the court when he was an advocate during the apartheid years, his passion for justice is palpable. Words and phrases were employed by him in the most exciting and imaginative ways, and he was particularly eloquent when engaging with the law and constitutional principles. And his bouts of verbal flourish were refreshing and inspirational amid the turgid and formal language of law. Now, in the book as well, I talk about Ishmael's appointment as Chief Justice. If I have time, I could go to that, but I want to leave a little bit of time at least for some comments and questions. So let me think about the just why I highlight these three cases. The three cases that I'm going to focus on go to the core of Ishmael's deep and abiding spiritual commitment and legal commitment to justice, as I said. And they also reveal that the central figure that he was in the transitional moment in South Africa, when the urgency of eradicating apartheid, and particularly the most egregious aspect of the apartheid, was most pressing. And so the three cases go to the heart, to the issues of dignity, of equality, of racial reconciliation, reparations. And Ishmael, you see him bringing his skills, his legal skills, his passion, his penmanship to the cases. The first case is the case of State versus Makwanyane, which was the first case that outlawed the death penalty. The second case that I want to deal with is the Azapo decision, which was a challenge to the the constitutionality of the Truth and Reconciliation Commission. And the third case is called Fraser versus Children's Court. It was essentially a challenge to a practice in which fathers who were not married to the mothers were not considered in the adoption of their children. So children born out of wedlock, the father's consent was not needed for adoption. And I'll tell you why I thought that this was one of the cases that I would include. So the State versus Makwanyane, I know that many of you are familiar with this case. It was a case which challenged the constitutionality of the death penalty. Now, the majority judgment was written by the President of the Constitutional Court, Arthur Chaskalson, but Ishmael penned his own judgment. And I think his judgment provides somewhat of a curtain raiser to the majestic sweep of the judgments that he wrote over his course as a judge at the Constitutional Court. So what he does in Makwanyane, it's a beautiful judgment. If you haven't read the Makwanyane case, particularly Ishmael's judgment, Arthur Chaskalson's judgment is also beautiful, and some of the other concurring judgments. And this was at a time which is unlike today, when the Constitutional Court judges each chose to write their own opinions. And so the judgments were 220 pages long and so on. That has shifted. But the judgments in Makwanyane are particularly, I think, inspirational. And as I said, Ishmael's was. And what he does is he looks at the apartheid state and how the death penalty was used in the apartheid state as a way to crush dissent. And as he points out in the case, that the Constitution was to be a decisive break from the past, and that only to retain that which was defensible. And so he goes through a beautiful discussion of the past reality and the future aspirations of the Constitution. He goes through sort of the question of dignity. There's a very interesting discussion of dignity in his judgment, in which he focuses not just on the right to life, but very much on the right to dignity. And then he talks about, with respect to the right to life, he talks about the sort of the finality of the death penalty. It's sanctioning the deliberate annihilation of life. And he states in an earlier judgment, of one of the first judgments that he had written, but in which the death penalty, in fact, had come before the lower court. Now he was looking at it as a constitutional court judge. And he said this about the death penalty, that it is the ultimate and the most incomparably extreme form of punishment. It is the last, the most devastating and the most irreversible recourse of the criminal law, involving, as it necessarily does, the planned and calculated termination of life itself, the destruction of the greatest and most precious gift which is bestowed on all humankind. And then he talks about the despair of the person, which would resonate, I think, in the United States as well when we think about death penalty cases here. He points to the despair of the person waiting impotently in custody for, as he puts it, for his date with a hangman, while noting that the death penalty manifests a philosophy of indefensible despair, and designating the person to be punished as beyond the pale of humanity, and which permits no rehabilitation, no reform, and so on. And he goes through the right to life, the right to dignity, and so on. And then he talks about the right to equality, which is implicated in the death penalty. That he stated that he could not reconcile the death penalty with the right to equality, noting the arbitrariness in the judicial process. He looked at the death penalty, which was not based on objective criteria, but he talks about a range of variable factors like the economic resources that's available to the accused, and what lack of economic resources means for the accused persons. And so he goes through this beautiful judgment, and he's part of the decision, and he agrees that the death penalty is unconstitutional for all these reasons. And why I included this case was because undoubtedly his very eloquent words in this judgment harked back to a time when he defended many political prisoners who, but for his defense, may have ended on death row, and the many who were actually executed. It was not only political prisoners who were subjected to the death penalty in South Africa, but the apartheid laws incorporated a range of non-criminal crimes, non-political crimes. So if a black man raped a white woman, for example, the death penalty would ensue, but not the case where a white man raped a black woman, and so on. And so the death penalty was used liberally by judges in South Africa. And in fact, there are some judges who were notoriously known as hanging judges. So it must have felt very satisfying for Ismail to close that odious chapter of South Africa's legal history. That was sort of trying to weave the thread from his representing people who may have ended up on death row. But I think one of the second case, the Azapo case, I won't go through all the sort of Ismail's, his analysis in the case. But what was significant about this case was it came as a challenge to the constitutionality of the Truth and Reconciliation Commission. And it came from the applicants in this case whose relatives had been murdered by the agents of the apartheid state. And what they were challenging specifically in the court were the amnesty provisions in the statute. So the amnesty provisions in the TRC provided that perpetrators who had committed the most heinous act could come before the TRC and tell the truth about their activities, which were for a political purpose. And if the amnesty committee determined that the truth was told, then that person would be both criminally immune from prosecution as well as civilly liable, as well as those who were supervisors of those persons would not be held vicariously liable. So this was huge as a bargain. So in the judgment, Ishmael goes through this bargain that was made, sort of exchanging justice as it was for truth. And it was really very, very, very painful for him and painful for the society, because the challenge came under international law as well as South Africa's constitution. But the court found, and Ishmael penned the decision, that the TRC survived constitutional muster, particularly the amnesty provisions and so on. And as I said, he focused on this bargain. And he also painstakingly points out in his beautifully written judgment that amnesty was pivotal to give birth to the post-apartheid society, because without the truth, the society would not be able to move forward and so on. But I've often wondered about the significance of Ishmael writing the judgment in this case, which laid bare the painful experience, the painful exercise, of balancing justice, truth, forgiveness, and reconciliation. And my sense has been that Ishmael was really the only one on the court who could write this particular judgment, which upheld the constitutional validity for amnesty. Justice, truth, and dignity had been the life motif of Ishmael's professional life. And as I said, the biography illustrates all of this. But the words of the judgment, when you read his words, suggest that he was able to transcend the pain and trauma of his own life to elevate the need for forgiveness and reconciliation in his judgment. And I hope that he did. And then finally, the final case is the case of Fraser versus the Children's Court, in which what he did was, and the reason why I mentioned this case was that Ishmael had an extraordinarily intense, close relationship with his mother. As I said, he was a devout Muslim who his marriage was an arranged marriage. He was very dedicated to his mother. And let me just give you an illustration. I started graduate work at Columbia in 1983. Ishmael had then been a visiting professor at Columbia for a few months. And, you know, when professors visit, they normally take their spouses with them. But Ishmael had brought his mother to spend his time at Columbia, which just struck me. And, you know, everybody knew his closeness with his mother. Why I mentioned this case is that he goes through he looks at a few issues, looking at the question of equality and so on, but he particularly focuses on pointing out why this was so difficult for him was the special relationship between the mother and the child, which is nurtured during pregnancy and breastfeeding and so on. So he goes through some beautiful prose about that relationship. But then he declares the statute unconstitutional, because he focuses on the status of marriage and the fact that Muslim marriages in South Africa were not recognized because they were potentially polygamous. So were indigenous marriages. They are now recognized. And so he talks about the disadvantage of people, of men particularly, who are deemed unmarried because the state refuses to recognize the relationships. So it's a beautiful judgment that he's written, that he wrote to illustrate this. And I chose the judgment because of, as I said, not just the focus on how equality plays out, looking at substantive equality, not just formal equality, because formal equality would not have, a formal equality analysis would not have reached the same decision, but also, as I said, the beautiful prose. So to close, because I hope I have some time for comments and questions, I thought I'd just show a few slides to give you a picture of Ishmael, some slides that I got. So let me share my screen here to show the slides. And so let me just do this. So the point is really what I wanted to try and do in this paper was really talk about an exceptional man who really was an important influence to me, to generations of law students, but more importantly on South African law, and that if he had lived for much longer, he certainly would have had the kind of influence that we see in Thurgood Marshall and other great American lawyers. So let me just show you some slides, a slideshow here. Can I share, Steve? Steve, are you there? Let me share the screen quickly. Okay, let me see. Can you see? Can you see the screen? All right, so that's a picture which I love of Ishmael and his wife. And then a picture of Ishmael's parents. This is Ishmael graduating at the University of the Witwatersrand in 1954, and there was a newspaper article about him and so on. When he became Chief Justice, South Africa's most prominent cartoonists wrote this. This was a very prominent cartoon, and it's about the judicial ivory tower, and appointing Ishmael Mohammed was about getting justice closer to the people. This is Ishmael Mohammed getting an honorary degree with President Mandela, who had appointed him as his Chief Justice. And this I particularly like. Ishmael in 1992 received an honorary doctorate at Penn, and one of the people who he received his honorary doctorate with was Candace Bergen. And then the bust of Ishmael Mohammed in the gardens of the Supreme Court in Namibia. And then this was what the highest court of South Africa, the Supreme Court of Appeal, where he became Chief Justice, looked like in 1998, 4 years after elections in South Africa. As you can see, all male, and the only Black person there is Ishmael. And that's just a picture of him. This is the book in which I have the essay. So I'd like to end there. Thank you for listening. I hope that there's time for some comments and questions. So let me stop sharing. Thank you. Jamie.
Wow, it's always interesting to be first. I'm sitting here with my baby, speaking of Ishmael's legacy. So I wanted to ask you, I was really interested in the Azapo case. I study, transitional justice. And so I was really curious, two things. The first is the characterization of amnesty, because it was limited and it wasn't always granted. And I'm wondering if you think that his decision affected the way the Amnesty Committee on the TRC evaluated the claims and denied amnesty to a lot of people. Now, even most weren't tried, but still, it was, a sort of, they tried to be more, not as broad as it's often said to be. And the second is how the Azapo case affects his legacy in South Africa today. Whether that has sort of affected his reputation as an advocate really against apartheid, and made people more of an apologist given all the critiques of the TRC and its legacy. Thank you.
Okay, thank you. I'm going to take Kim's question as well. I'll just take the two questions at a time. Thank you, Jamie.
Yeah, thanks so much for this, Penny. That, I've always been curious because he was sort of the invisible judge, at least as I could see from here, because he wasn't on the international conference circuit that much. But his opinions were very strong. And so I wondered, when I was listening to you talk about his life story, it made sense out of something in South African constitutional law. And I just wondered if this was an accident or something real, which is that, if you grow up learning American constitutional law, as many on this call have, you learn that rights are almost like mutually exclusive, right? If something's a free speech case, it's probably not also something else. That, there's and the cases where there are intersections are problems, but by and large, The US Constitution thinks of rights as totally separate, each with their own jurisprudence, each with their own tests. There isn't any effort to integrate across all the rights how to think about them. And in South African constitutional law, especially those early cases from the 1990s where the 200-page opinions, there were very rarely any cases that only relied on one right. So, the Makwanyane case could have just been right to life, full stop, right? But it turns out to be this big case about dignity, not because right to life wasn't sufficient, but because the court always seems to weave together rights as kind of a tapestry. And you don't ever just pull one thread out of it. And so as you were describing, Ishmael's early life and sort of all the different ways in which, the apartheid system affected his life, I wonder if that way of thinking of rights is all interconnected, grows out of the experience of so many people with apartheid, where it wasn't just one thing, but it was the way in which all the laws of apartheid reinforced each other, so that just changing one law would never have worked. So this is just on the way of thinking about rights and Ishmael's role in developing that.
Thank you, Kim, and thank you, Jamie. So why don't I start with Kim? I'll start with your question and move on to Jamie's. I think that you asked whether those many rights that the court addresses in one case grows out of the experience of apartheid. I would say that it grows out of the experience of the sort of how the Constitution was drafted, and particularly the committee that was set up to draft the Constitution, and Heinz Klug was on that committee. I think what it is that, remember that the new South African Constitution was really the last constitution of the 20th century. It was an expansive constitution that in many ways benefited from 4 decades of human rights advocacy, constitutionalism, the end of the sort of Cold War, and so on. So a lot. I mean, as some people were in South Africa between 1990 and 1994, it just felt like one large constitutional law workshop, apart from anything else. So, and then the text of the Constitution also incorporates so much. It incorporates intersectionality. The Constitution recognizes that, the way that various areas of discrimination affect people based on, their context. And sometimes you do require intersectionality, the rejection of version of formal equality for substantive equality, which I think dignity provides, and so on. So it's in the text of the Constitution, and that's why I think the Constitutional Court at the beginning, it was just wonderful. I mean, who would not want to be a judge on the court in 1995, when the Constitution also says, in considering the Constitution states, in deliberating, you must consider international law and you may consider foreign law. I mean, that would have been Scalia's nightmare. But for the South African Constitutional Court judges, this was an extraordinary repertoire of laws and so on that they could choose from. So I think it does grow out of the experience, but then of course, the ANC had waged a long struggle, and so on, the PAC, and then the Constitutional Committee, and Heinz may have more to say about that, but Heinz was right there with people working on the text. The second thing is Jamie, your question about Azapo. It's very interesting. The Azapo case now, many people are revisiting the case, because the reality is that the truth, to a large extent, large parts of the truth were excluded. And some people got amnesty. There was questions about it. So that bargain, and the reason I think why Ishmael found and other judges found the amnesty provisions constitutional, was because they thought that the TRC was going to achieve what it had set out to achieve. Well, with amnesty, many people were denied amnesty, but the tragedy is they weren't prosecuted. So they're people who actually committed these heinous acts, who didn't tell the truth before the TRC. Some of them didn't even bother to go to the TRC, and they just, living in South Africa with impunity. Professor Zozo Diani-Mango is sort of written about the crime of apartheid generally and the International Criminal Court. I don't know if she's on this case, but again, she also looks at this idea that there's a measure of impunity. So I'm not sure how it affected the granting of amnesty, Jamie, because the the Promotion of National Reconciliation Act, actually, Promotion of National Unity and Reconciliation Act, provided the conditions and set out how amnesty was to be granted. So you're right, it was conditional. I don't know if the Azapo decision affected that. I think the statute was clear. But I think today there's a big debate in South Africa about the status of reconciliation and whether, in fact, the TRC did achieve what it had set out to do. And I would say that my position has always been that without the TRC, South Africa couldn't move from apartheid to democracy. But the unfinished business of the TRC needs to be addressed. So I hope that answers the question.
Can I ask a question? Are you taking
Arzu? Yeah, just two quick questions, Arzu and Raphael.
This is a very quick question. Having just written a book about mercy and forgiveness in Islam, you highlighted several times his piety, his faith. And I was wondering, particularly in the second case that you mentioned, if there's any evidence of the importance of his belief in mercy and forgiveness coming out of his faith in the case challenging the constitutionality of the TRC.
Okay, thank you. Raphael?
So thank you, Professor Penelope Andrews, for this fascinating conference on the biography of Ismail Muhammad. I was remembering Ralph Dahrendorf's research on the German judges and their proveniences in terms of classes, and also in terms of elite universities and the consequences that this provenience had in their decisions, in their legal decisions. And those consequences were negative consequences. And you were speaking about positive relationships between the provenience from the short term from Justice Ismail and his decisions. Are there also, so you described it positive in a way, in a positive side, yeah? Are there also negative signs that may be foreseeable? Thank you very much.
Yeah, thank you, Raphael. Thanks for that question. So I'll start with yours and then I'll move on to Arzu's question as well. I think that the thing I can say is, ironically, the experience of apartheid and living under apartheid was horrendous for everybody. Of course, whites benefited from apartheid, but to a large extent, apartheid was, had been declared a crime against humanity. The anti-apartheid struggle was the most prominent late 20th century global struggle, and so on. So by the time the Constitution was drafted and the judges had to sit on the court and interpret the Constitution, there was a purposive approach. The society had decided, we're going to leave this behind and we're going to go here. I mean, a new court was set up, a constitutional court. So I think that the experiences were positive in the certainly the first decade or so. We're now in South Africa, 25 years later, in a different period in which there's huge questions, not just about the text of the Constitution and so on, but the whole arrangement that gave rise to the Constitution. So I don't know sort of how experiences then will impact the kinds of the influences that you mentioned. It would be interesting to see, and it would be interesting to look at a judge who started sitting maybe 2 years ago and look a few years down the road. But I think that Ismail very much felt himself as there was a particular job to be done, there was a particular vision. Which leads me sort of to the second issue that, Arzu's question about his piety. He was a devout Muslim, and so on. I remember as a young student, young lawyer, where all we wanted to do was party and so on. And if Ismail, I remember one case that we were working on with him, and he was, it was midnight, he was still sitting in his suit and tie, and we were like ready to go and drink somewhere and so on. So it was a very different approach. He was a good person. And the question of mercy and forgiveness, it's interesting because I know personally his bouts of anger. He was angry on so many levels. I could never understand sometimes, his anger at people that I also admired, like Arthur Chaskelson was my boss, and Ishmael, there was he was a complicated individual, let's just say that. And I think a lot of the complications came from the hurt that he had experienced and so on. But I think that Arzu, the question about mercy and forgiveness, it came from, obviously it must have come from his own religious beliefs, his spirituality and so on, but also because he realized what the project was, that in 1995, that the Truth and Reconciliation Commission could not be jettisoned. The whole project of transformation in South Africa might be jettisoned. So I think that he was prepared, on a whole range of things, that revenge was not an option, but that reconciliation was, to be pursued. So I think that's the reason why. And I think we have now reached our time. We've gone 1 minute after time. Thank you everybody for listening and for being here. I really appreciate it. And I'll see you at the next session. Thanks a lot.